Hello everyone, I'm Susie.
I'm Julia.
Today we talk about law of contract.
1. Explain what is meant by a contract and where a contract can arise from.
For definition, a contract is a legally binding agreement between two or more parties. It can be oral or written. The parties involved exchange considerations such as goods, services, or money, and are obligated to fulfill the terms of the agreement. If a contract is violated, it can be enforced in court. For origin, contracts can arise from various situations. They usually stem from the express or implied agreements of the parties involved. For example, when buying a product in a store, there is an implied contract that the customer will pay for the item, and the store will provide it. Contracts can also be formed based on the law, such as in the case of implied in law contracts. So, second question. Explain what is meant by an agreement based on Article 1320 of the Civil Code.
The specific content of Article 1320 of the Civil Code may vary by country. In general, for an agreement to be valid under this article, it usually requires elements such as the capacity of the parties, mutual consent, a legal object, and consideration. The parties must have the legal ability to enter into the agreement, and they should reach a consensus on the essential terms. The object of the agreement must be legal, and there should be some form of consideration exchange between the parties. The third question. Explain what is meant by the principle of freedom of contract and the principle of consensualism. The third question. Explain what is meant by the principle of freedom of contract and the principle of consensualism.
For freedom of contract, this principle allows parties to freely determine the content and form of their contracts within the limits of the law. They can choose with whom to contract, what rights and obligations to assume, and how to perform the contract. For consensualism, it emphasizes that a contract is formed by the mutual consent of the parties. The focus is on the meeting of the minds of the parties rather than on formalities. As long as the parties reach a consensus on the essential terms, the contract is considered valid. 4. Mention the forms of default.
Mora accepiendi, referred to as creditor's default. It happens when the creditor refuses to accept performance or payment when it is properly offered by the debtor. Compensation mora. This is mutual default, which occurs when both the debtor and creditor are in default in reciprocal obligation. The last question. What is the difference between an MOU and an agreement?
First, enforceability. An agreement is enforceable in a court of law, while a MOU is generally not, unless it is signed in exchange for monetary consideration. Second, binding nature. An agreement is binding on the parties, while a MOU is usually non-binding, although parties may be bound by estoppel. For elements, the elements of an agreement are offer and acceptance, while a MOU includes offer, acceptance, intention, and consideration. Form. An agreement can be oral, written, or implied, while a MO is always a written document. So this is our all exercise. So thank you for watching.